Hello everyone, my name is Shirley Nabarte. My topic is all about Financial Rehabilitation and Insolvency Act of 2010. The commandment order will include a stay or suspension order which shall have the following effect. Stay or suspension order shall first, suspend all action or proceedings in court or in otherwise for the enforcement of claims against the debtor. Second, suspend all action to enforce any judgment attached on other provisional remedies against the debtor. Third, prohibit the debtor from selling, incumbering, transferring, or disposing in any manner any of its properties except in the ordinary course of business. And fourth, prohibit the debtor from making any payment of its liability outstanding as of the commencement date except as may be provided in the law. Aside from the debtor, its creditors, and the rehabilitation COVID, there are other parties involved in the proceeding, which include the following: the rehabilitation receiver. The rehabilitation receiver is a person appointed by the court to closely oversee and monitor the operation of all debtor, ensure that the value of the debtor property is reasonably maintained during the pendency of the proceeding, and to implement the rehabilitation plan once approved. Section 29 provides the qualification of a rehabilitation receiver. The rehabilitation receiver shall have the following minimum qualification. A. A citizen of the Philippines or a resident of Philippines in the 6 months immediately preceding his nomination. B. Of good moral character and with an acknowledged integrity, impartiality, and independency. C. Has the requisite knowledge of insolvency and other relevant commercial law, rules and procedures, as well as the relevant training and or experience that may be necessary to enable him to properly discharge the duties and obligations of the rehabilitation receiver. And D. Has no conflict of interest, provided that such conflict of interest may be waived expressly or impliedly by a party who may be prejudiced therefore. Other qualification and disqualification of the rehabilitation receiver shall be set forth in procedural rules taking into consideration the nature of business of the debtor and the needs of to protect the interests of all stakeholders concerned. The receiver, however, the rehabilitation plan. The rehabilitation plan refers to a plan by which the financial well-being and viability of an insolvent debtor can be restored using various means, including but not limited to forgiveness, debt rescheduling, reorganization, or quasi-reorganization, dashes in pago, debt equity conversion and sale of the business or parts of it as a going concern or setting up of new business entity as prescribed in Section 62 hereof, or other similar arrangement as may be approved by the court of or creditors. What is the cramp-down effect? Section 68 discusses the cramp-down effect. Cramp-down effect, a restructuring workout agreement or rehabilitation plan that is approved pursuant to an informal workout framework shall have the same legal effect as confirmation of a plan under Section 69 whereof the notice of the rehabilitation plan or restructuring arrangement or plan shall be published once a week for at least 3 consecutive weeks in a newspaper of general circulation in the Philippines. The rehabilitation plan or restructuring agreement shall take effect upon the lapse of 15 days from the date of the last publication of, of the law. In a decided case of the Supreme Court, it was ruled that the rehabilitation plan may be approved. A rehabilitation plan may be approved even under the opposition of the creditor holding a majority of the corporation. Total liabilities if there is showing that rehabilitation is feasible and the opposition of the creditors is manifestly unreasonable, also known as the cramp-down clause. This provision, which is currently incorporated in the FRIA, is necessary to curb the majority creditors' natural tendency to dictate their own terms and the conditions to rehabilitation, absent due regard to the greater long-term benefit of all stakeholders. Otherwise stated, it forces the creditors to accept the terms and condition plan, preferring long-term viability other immediately but incomplete recovery. Let us now go the third remedy of distressed business, that is liquidation. In cases assigned by the Supreme Court, it held that liquidation or settlement of the affairs of the corporation consists of adjusting the debts and claim, that is, of collecting all its due the corporation, the settlement and adjusting of claim against it, and the payment of its just debt. It involves the winding up of the affairs of the corporation, which means the collection of all assets, the payment of all its creditors, and the distribution of the remaining assets, if any, among the stakeholders thereof, in accordance with their contracts, or if there be no special contract on the basis of respective interest. RA number 10,142, otherwise known as the Financial Rehabilitation and Insolvency Act of 2010, now provides for court proceedings in the rehabilitation or liquidation of debtors, both juridical and natural person, in a manner that will ensure or maintain certainty and predictability in commercial affairs, preserve and maximize the value of the asset of this debtor, recognize creditor rights and respect priority of claim, and ensure equitable treatment of creditors who are similarly situated. In Section 90, provides the mode of initiating a voluntary liquidation. An insolvent debtor may apply for liquidation by filing a petition for liquidation with court. The petition shall be verified, shall establish the insolvency of the debtor, and shall contain whether as an attachment or as a part of the body of the petition. A. A schedule of the debtor debts and liability, including a list of creditors with their address, among of claims and collaterals or security, if any. B. An inventory of all assets, including receivables claimed against third parties, and C. The name of at least 3 nominees to the position of liquidators. When is a If the petition or the motion of case may be is sufficient in form and substance, the court shall issue a liquidation order mentioned in section 112. At time during the pendency of court supervised or pre-negotiated rehabilitation proceedings, the debtor may also initiate liquidation proceeding by filing a motion in the same court where the rehabilitation proceedings are pending to convert the rehabilitation proceedings into liquidation proceedings. The motion shall be verified, shall contain or set forth the same matters required in the preceding paragraph, and state that the debtor is seeking immediately dissolution and termination of corporation exent. At any time during the pendency of a rehabilitation court supervised or pre-negotiated rehabilitation proceeding, 3 or more creditors, the aggregate of whose claim is at least either 1 million pesos or at least 25% of the subscribed capital or partner's contribution of the debtor, whichever is higher, may also initiate liquidation proceedings by filing a motion in same court where the rehabilitation proceedings are pending to convert the rehabilitation proceedings in liquidation proceedings. The motion shall be verified, shall contain or set forth the same matters required in the preceding paragraph. The stated that the movant are seeking the immediate liquidation of the debtor. In nutshell, the remedy of corporate liquidation goes through the following process. If the petition or motion is sufficient in form and substance, the court shall issue an order. First, directing the publication of the petition or motion in a newspaper of general circulation once a week for 2 consecutive weeks, and second, directing the debtor and all creditors who are not the petitioners to file their comment on the petition or motion within 15 days from the date of last publication. If after considering the comment filed, the court determines that the petition or motion is meritorious, it shall issue the liquidation order mentioned in section 112. A petition for liquidation is filed either by the debtor or the creditors. It can also happen that the initially filed petition for rehabilitation or other remedies have been converted into liquidation proceedings. An order of liquidation is issued which can either contain the directive for the appointment of a liquidator or closure of a business or termination of corporate powers or from gathering, preservation, or sale of corporate asset. In case of the latter, the creditor's claim will then be adjudicated. The proceeds of such sale will be distributed according to priority claims or rules in preference of credits after which the corporate will now be dissolved. And that's all for my report. Thank you.